see them when you were in the elevator?
Not in the elevator, no.
You're not at all. Windows are down. Kids are in there. A bunch of people come up to the car, correct?
Yeah.
What would have stopped any of them from getting into the car, the running car, and driving away with your kids? It's a very huge...
changed their lives because I left them for 60 seconds.
You didn't leave them for 60 seconds.
Twice. I'll clean that up.
Okay.
How much?
Still water?
Yeah, they keep thinking it's a toy.
No worries.
So.
Alright, let's have a seat.
Okay, so what happened today?
So I went to deliver food to the Cleveland Clinic, gastroenterology. So I got there, I parked in the front next to the volley people and the door greeter guy. So I rolled my windows down, I kept the air on. I went down in the car 4 times within the 10 minutes that I was there. And because I had to keep bringing like food up to the second floor, and then there was a window upstairs that looked down on my car. So twice I looked. So the last time I was up there, well, actually, let me backtrack. So the second time I went down for food, this nurse, she said, I'll just stand here by your car because I see your kids are in the car. And I said, you don't have to do that. I mean, I appreciate it, but you don't have to do that. Like, I can see them when I go up because I'm right by the window. And I said, the valet guy's right there. I said, they're fine, but okay. So then the last time I went up, this lady came, this nurse, and she said, I just want to let you know that lady that said she was going to stand by your car, she said they're going to call the cops on you if you don't hurry up and go downstairs. And I was like, okay. So then I look out the window, I see there's a man standing by the car this time, which I was just looking 2 minutes ago. And so I'm like, well, what the hell? So I walked down, took me like 30 seconds to walk down, and I said, can you please get away from my car? I don't know where to ride my car. And he said, well, you know it's illegal to leave your kids in the car. And I said, I was told by Lakewood Police Department that you can be within 25 feet of your vehicle as long as, you know, you can see your kids and it's not a problem. And I heard another lady from Cleveland Clinic calling the cops, and I said, I don't think I've done anything wrong, so I'm going to call. So I called Westlake, and she's like, well, you know, I don't know if it's illegal or not, but you still shouldn't do it. And I said, okay, well, I had to bring the food and drop it off, so I said, I'm just going to come down here because maybe I'm misinformed, maybe Lakewood misinformed me, maybe, I don't know, but I'm pretty angry because there was like 3 or 4 people by my car acting like I just left my kids.
On May 21st, 2024, Ohio officers responded to a child welfare call at a hospital parking lot. The footage that followed raised a deceptively simple legal question. At what point does a parenting lapse become a criminal act? The controlling statute is Ohio Revised Code Section 2919.22, Endangering Children. Under subsection A, the state must prove the defendant created a substantial risk to the health or safety of a child by violating a duty of care. The word substantial is doing significant legal work here. Ohio courts have consistently held that a theoretical risk is insufficient. The risk must be real and appreciable. In State v. McGee, the Ohio Court of Appeals confirmed that actual harm need not occur, but the prosecution must establish conditions that created a genuine, non-speculative danger.
Let me ask you this. So the windows were down, the car was running.
The air was on.
The air was on, which means the engine was on, or?
Yes.
Okay.
Okay, let me
Well, hold on.
change that, though.
Let him talk. Let him
Right.
finish.
Well, it was on for half the time, basically. Because
Okay,
she
were the
shut
keys
it
in the
off.
car?
Yes.
Okay.
She shut it off.
Yeah, she shut the car
So
off
she can climb
midway.
into the front.
She got out of her seatbelt, yeah. I saw her get out of her seatbelt when I
How
went
did you
down.
get from the first floor to whatever floor you were delivering on?
I took the elevator.
Okay, could you see
And
them
then
when you
I
were in
went-
the, could you see them when you were in the elevator?
Not in the elevator,
No.
no. When I walked past by the window when I left the elevator.
Okay,
So there was like a 60-second period each
do
time.
you think that's a problem since the kids, like one of them could climb from the back seat to the front seat? Now here's, I
Right.
didn't mean to interrupt you.
So here, no, you're not at all. Windows are down. Kids are in there. A bunch of people come up to the car, correct?
Yeah.
What would have stopped any of them from getting into the car, the running car, and driving away with your kids?
Well, I assumed the valet guy and the nurse that said.
Do you know them?
No, I didn't know them. I had talked to them for like 30 seconds, or I had talked to the nurse for like a couple minutes because she, you know.
But this was already after you left the car.
Yes.
And then it come back.
Yes.
What for the children?
Not 100% safe, but I didn't think that it would be detrimental, I guess. Like,
Would it have been detrimental if the kids crawled out of the window into a parking lot, a busy parking lot? There's a lot of cars around. They walk between cars. The kid could have walked out. Someone might not have been able to see him. Would that have been detrimental?
Yeah. Yes, and in that case, I would have called the police.
Well, yeah. Then we're reacting to something that you created, right?
Okay.
Right. Like this could be, like we don't have to do all that if you just either find someone to watch the kids while you're working, or you got to figure it out. You had the kids, right?
Well, normally they come with me, and I've never had a problem. I've been doing this 2 years. I have never had a
So you're
problem.
saying you regularly leave them in the car?
My friend normally comes with me, my friend Michaela. She normally comes, but, you know, I didn't want to bother her. And I have never had a problem with my kids in the car. He cannot get out of his seat at all because he is still in, you know, the car seat. I strap her in, but she can get out of her car seat. So
Okay. What if she gets up in the front? Like we know that she can do that, and she gets it into drive somehow. Is that a
I
problem?
don't. Yes, it would be a problem, but I have never.
So we have three different
that has
options.
never. She can't reach the pedal.
Okay, she just puts it in reverse or puts it in drive or even in neutral. It's going to go rolling down the parking lot.
But she can't do that.
You-
My car is not easy to do that. You have to push it in.
So you don't see any problems with anything?
No, I totally see
Okay,
that.
what's his
it's
name?
not-
What's his name? Here's what's going to happen. This is definitely a child endangering. Okay,
But I'm trying.
just listen to me. Okay, for both of the children. All right. So with that goes a report. There's going to be criminal charges for this.
But I'm asking
Just
you
just-
to please
just listen.
work with me on this because I can't.
Listen to me. Listen to me. Okay. Whether you came up here or not, you coming up here was a reaction to other people's reactions of seeing your kids left in the car.
No, I came up
Hear-
because
hear me-
I want to
hear-
know
hear
if
me
I'm
through.
right. I want to know.
Well,
if I know
I'm
the
telling
law.
you, you're not. You're not. Okay. So what you did was very dangerous for your kids. I mean, it's not safe for a dog to be left in a car, let alone two children.
But what I'm saying is I kept
Could you finish?
looking.
Could you let me finish? It doesn't matter because there's points and times where you couldn't see your children. They're sitting there in a running car with the windows down, keys in the car, with strangers who are walking up to the car. A lot of things can
And I
happen.
saw that, and I'm.
But it's still a situation that you created. Okay?
3 factual elements weigh in favor of the prosecution. First, the vehicle was running with windows down in a public parking lot accessible to any passing stranger. Second, there were repeated intervals of approximately 60 seconds each during elevator transit where neither the mother nor any designated person had visual contact with the children. Third, the older child was capable of unbuckling her own car seat, creating a mobility risk the mother herself acknowledged on camera. 3 factual elements, however, weigh in favor of the defense. The engine was running with air conditioning active, eliminating the heat exposure risk that dominates most child-endangering precedents. The total unsupervised duration per interval was brief, measured in seconds, not minutes, and valet staff were physically present in the immediate vicinity. A skilled defense attorney would argue that these conditions do not satisfy the substantial risk threshold and would move to dismiss at the preliminary hearing stage. The mother cited advice from Lakewood Police Department that a parent may leave children in a vehicle while remaining within 25 feet and maintaining visual contact. That advice has no basis in Ohio law. No provision in the Ohio Revised Code establishes a distance-based safe harbor for leaving unattended children in vehicles. Under Ohio's mistake of law doctrine, a good faith belief that conduct is lawful does not constitute an affirmative defense unless that belief was based on a formally issued legal opinion. Advice from a patrol officer, even if genuinely given, does not qualify. The reliance was understandable but legally insufficient. The mother's decision to decline the nurse's offer to stand watch carries independent legal weight under the duty of care element. Ohio courts have held that a parent's duty of care is continuous and non-delegable to strangers. However, actively refusing an available safety measure compounds the statutory violation. It undercuts any argument that the mother took reasonable precautions, which is precisely the factual hook the prosecution would emphasize at trial. The constitutional dimension of this case involves competing interests the Supreme Court has addressed directly. In Parham v. Jr., the court recognized the state's parens patriae authority, the government's standing to act as protector when a child's welfare is at risk. But in Troxell v. Granville decided in 2000, the court reaffirmed that parental rights in child-rearing are fundamental liberty interests protected by the 14th Amendment. These two principles exist in tension. Criminal prosecution for a brief non-injurious lapse must survive proportionality scrutiny, and courts in close cases have found for the defense.
All right, so what's going to happen is you're taking a report for child endangering. There's going to be some charges that are going to be filed, okay? We're also going to have to contact Children's Services. You live in Lorraine?
I live in
Lorraine County? Okay, so we're going to have to...
Is there any way from working that I'm telling you?
No, there's not.
I don't have anybody else for these kids. Like, I'm their mom. And I know that I shouldn't have left them for 60 seconds here and there, but I didn't intentionally try to hurt them, and I would not ever try to put them in a situation.
We cannot ignore this.
But I don't feel like it was extreme, and I was trying to.
What would have been extreme?
So
what would have been extreme? Your kids would have.
If I would have left them for a long period of time, I was only gone, and I was watching them while I was gone for 10 minutes tops. The nurse even told me that the lady was going to call the cops on me because they know that I kept checking on my kids. I told them, I said, I have to hurry, my kids are downstairs, here's your food. I'm telling you, I'm begging you. Like, I know that...
Listen, our hands are tied, especially when it comes to situations like this. Our hands are tied, we have to report this, we have to take a report, and at the same point in time, there's going to be criminal charges with this. Okay, whether hold
to do that.
Well,
I know that.
Let's go back to what I said. There's certain things where our hands are tied. This is one of them.
But it's not. Your hands are not tied.
Yes, our hands are tied. You're not telling me if my hands are tied or not. I am telling you that. Okay.
I will give this job up. I'm telling you, my kids do everything to me.
I understand that. I understand that, and I understand that you're trying to take care of your children by working. But this situation, we can't ignore it. Hold on a second. It has to be addressed.
And I'm addressing it.
It has to be addressed by policy and procedure and by law, and that's what we're going to have to do.
But I don't feel like I broke the law because I didn't see them for 60 seconds.
Then if you don't hold on a second, if you don't feel like you broke the law, there's recourse in court.
But this is a huge deal.
It is a huge deal.
It's a very huge deal. Their lives because I left them for 60 seconds.
You didn't leave them for 60 seconds.
Twice. Twice I was in the elevator. Okay, 3 times I was in the elevator for 60 seconds.
Why couldn't they have come with you?
I can lose my children over this because I made one mistake.
I don't think you're going to lose your children.
I will quit this job right now.
I think you need to take some classes though, and you need to understand. So what we're going to do today, you're going to be allowed to leave with your children, okay? We're going to do a report, and you are going to be you're getting charged with child endangering, okay? You go to court, and they're probably going to you're going to receive a call from 696 Kids. They're going to come and check on the welfare of the children, okay? That's what's going to happen. We're not arresting you today.
On officer, conduct the lead officer made the correct charging decision. A custodial arrest in a first offense no injury scenario would have been disproportionate and legally vulnerable. Issuing a citation and initiating a Children's Services referral reflects appropriate exercise of prosecutorial discretion and is consistent with Ohio's mandatory reporting framework. The officer also correctly allowed a court, not the patrol level, to resolve the contested question of whether the facts satisfy the substantial risk element. That is the right call. The lead officer receives a B+. The statutory analysis was accurate. The charging decision was proportionate and the de-escalation technique was genuine and effective. 1. Procedural concern. The interview was conducted at a police station, which courts have recognized as an inherently coercive environment under Burkhamer versus McCarty, without an explicit advisement that the mother was free to leave and the interview was voluntary. Any incriminating statements she made carry a potential suppression risk at the Miranda threshold. The mother receives a C. The elements of Ohio Revised Code Section 2919.22 were objectively present. The short duration and absence of injury are mitigating, but they do not negate the statutory violation. Declining the nurse's offer, acting on unverified legal advice, and repeating the conduct across multiple trips collectively satisfy the pattern the statute is designed to address.
Their grandmothers work at Children's Services. We just saw them yesterday.
Okay.
I'm not letting them take my kids from me.
Listen,
We didn't say we are.
I'm not.
we're not taking your kids from you. You need to address this properly.
But you don't have to address it through the court. I came up here. I came up here as a good parent who cares about her kids.
Answer him and give the last name, please.
I did. Children!
Do you want to go to
No.
right now? All right, then calm down for your children. Act like an adult.
I do.
What's Anthony's phone number?
I don't fucking know.
And that's not appropriate language in front of your children. Here's the
Swearing?
reason. Yeah, it's
Everybody
not.
swears.
It's not.
Everybody swears.
Do you want to give a written statement of the events
No.
today? Okay. Which car is yours?
The Ford Focus. Hi, can you give Michael a message to call me back as soon as possible? This is just,
What's that? Not
and
yet.
it's urgent.
I got it.
Yes. Chris Skyal, Rystial.
Sorry.
No, it's gonna be a new case. Yes, but it's very urgent. I'm at the police station, so if you can have him call me as soon as possible. Thanks, bye.
What's an address for you? Okay. All right. So, like you explained, we have to call Children's Services. There's going to be charges that are going to get sent to you in the mail with a court date.
Sure.
Okay.
Yep.
Do you have any questions?
Nope.
All right. Make better choices.
Be for you.
Before closing, one legal lesson applies broadly to any parent or caregiver who transports children while working. Ohio Revised Code Section 2919.22 does not require proof of actual harm. It requires only substantial risk. That is a low threshold, and the courts apply it objectively, not subjectively. If a child is mobile, a vehicle is running, and a parent is out of sight even briefly, the statutory elements may be satisfied regardless of how careful the parent believes they were. The correct precaution is not to estimate distance or duration. It is to ensure a known responsible adult is present before leaving any child unattended in a vehicle. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.